Marcus, thank you for being here this morning. I will hand it over to you now.
Thank you, Nate. Good morning, everyone. As Nate mentioned, I'm Marcus Jaynes. I'm an immigration lawyer. My office is in Westbrook, um, and I primarily focus in my practice on business-related immigration. Um, we have four attorneys with our office, and we sort of divide our practice between on the one side, business and employment related immigration, and on the other side, what we call family based immigration, but it's really all the non-business immigration. So individual processes, family based immigration, and um, humanitarian and deportation defense as well. Um, we are a total of about 10 individuals in our office, four attorneys and six staff. And yeah, we've been around for quite a while. We're one of the only firms in Maine that focuses exclusively on immigration. For the last 10 plus years, we've been working with Maine and other states, Maine employers on the H-2B process, which involves bringing workers from outside the US to assist with seasonal needs. Um, so that can be in, let's see here. Hopefully my slides will start cooperating. Here we go. Um, So really any employer in any industry can use the H-2B program. Hospitality is certainly a big one, um, particularly in Maine, where we have a booming summer tourist industry. And, we certainly have our share of winter cold weather activities and industries as well. Other ones, landscaping, construction, manufacturing, really any business, as long as you can demonstrate a temporary need. We'll talk about that in a second. Um, the need, the employment for in order to use the H-2B program has to be um, non-agricultural. So if the work is agricultural, that's going to be the H-2A program. Otherwise, you're in H-2B world. And as far as a temporary need, what does that mean? So there are four types of temporary need. Really, only two are typically used. Um, and temporary generally means up to 10 months a year. Um, And a seasonal need is really an example of that is a business that closes in the off season and doesn't have any workers in that occupation or job, like a cook or server or housekeeper, things like that, because they're closed. So that's a very clear. You have a season where you need workers and a season where you don't. Um, the business could be open year round. For example, a lodging establishment that has a restaurant and the restaurant closes in the off season, but the hotel is open year round and no cooks are employed during the off season. A peak load need is where a business has workers employed in a given occupation year round, but during a certain time of the year, they need more of those workers. Um, and that, is quite common. A restaurant that's open year round, but is slammed with customer demand and business during the summer. They need extra cooks, they need extra servers. And same with lodging establishments. Um, Intermittent need and one-time occurrence don't come up too often. An intermittent need is something that kind of pops up occasionally, unpredictably. Um, Certainly not the case with most, kind of tourist-oriented operations. A one-time occurrence really is pretty rare in the H-2B world. With some exceptions, it involves an employer that um, has not hired a person in a given occupation in the past and won't need them again. Um, and that can involve year-round employment as an exception. Um, so just to summarize real quick what we've talked about so far. So the temporary employment can't be year-round, generally speaking. Um, if you're asking for year-round employment outside of the one-time occurrence, then you're not generally eligible for H-2B employment. And how do you prove your temporary need? Generally, we use payroll and revenue or sales data. So for a restaurant, showing that in past years you have, more cooks on payroll, and they're, temporary cooks who come on for the summer and leave at the end of the summer. And then showing that your revenue is higher. And this can sometimes be a chicken and egg issue, because sometimes an employer might say to, we say, well, to demonstrate your season, we need to see your, payroll records that show you've had temporary cooks during that high season. And they might say, what do you mean? The reason we're using a program is because we couldn't get any temporary cooks. That's why we want H-2B workers, because we can't get anybody to help. Um, and that's an argument that can be used to be able to say, look, we haven't been able to hire temporary staff. We want, and therefore we haven't been able to be open as much as we'd like to be. We open limited hours. Some days of the week we're closed. If we had H-2B workers, we'd be able to be open more, capture more customer demand, and grow our business. We've made that argument successfully many times. Um, but sometimes it is possible to show even when you don't have workers, you can show, look at the revenue between May and September compared to October through April, and you'll be able to easily see it. Um, Overall, the temporary worker H-2B program, like many areas of employment-based immigration, requires employers to show that they can't hire U.S. workers. And in order to show that, they have to advertise. Um, so the way the advertising occurs in the H-2B program these days is through state job orders. In Maine, that's through the Maine job link, and also through employers are required to contact former workers who held the position. So if you have temporary workers you hire every year and then you lay them off at the end of the high season, you have to contact those U.S. workers and ask them to come back. And if they do come back, usually we can prevent that from dropping the number of workers that you need. Basically, the way the program works is you say to the Department of Labor, I need X number of cooks added onto my staff for my busy season. And that number should include U.S. workers who you're planning to come back, as well as additional foreign workers that you want to add to your staff. So let's say you put in for 10 cooks, um, and if you get a couple of your U.S. workers, your U.S. citizens, or people who already have status in the U.S. as permanent residents or otherwise, and they return, oftentimes you can say, "Hey, don't reduce me down from the 10 I asked for. These people that are coming back, I expected back." And that's often possible. Um, but if you have new people, new U.S. workers who apply, then, let's say you have two new U.S. citizens who apply and they say they want the summer job, you have to hire them. And you would report that to the Department of Labor, and that would drop you down from 10 to 8, but you'd still get your 8 certified workers that you could use the immigration system to hire. Um, and let's be honest, I think most of you are probably saying, US workers that are new applying? No. I mean, over and over we see employers who don't get applications. They're just, that's why they want to use this program because they're not getting local folks from the community or US citizens you know, who want to take these jobs. And then when they do get US citizen applicants, I hear over and over again that these folks don't show up for the job, or they show up for a couple weeks and then they leave. Um, generally advertising these positions, you're not going to get a lot of applications or any sometimes, and you can demonstrate that to the Department of Labor and get certified for the H-2B process. Um, Another piece of the process, um, like many areas of the immigration system, it's built to protect U.S. workers. So before the government will let you hire foreign workers and sponsor them for status based on that job offer, you have to demonstrate you've tried to recruit U.S. workers and that if you have U.S. workers employed, you're not going to treat your foreign workers differently. Um, and that's a protection both for the foreign workers as well as U.S. workers. Another protection is that the whole process is an employer expense. You can't require your foreign nationals to pay for legal fees, visa costs, transportation, and so forth. Um, so there are substantial costs involved. But generally, as Nate mentioned, this program is a lifeline that really helps a lot of businesses. Let's see what we have next here. So the numbers and the cap. Um, Everybody talks about the H-2B cap, and that's because it's really low. 66,000 new H-2B numbers are available each year for the whole country. That's not a lot. And that cap is met every year, and it's divided into the two halves of the fiscal year. So the first half being what we call the winter season generally, October 1st through March 31st, 33,000 new H-2B numbers allocated there. And then from April 1st through September 30th, another 33,000 numbers. And these dates are start dates for employment. It's not as though those are the dates that the workers have to work. It's just those are the start dates that are allocated to those numbers. Now, to give you an idea of how low the numbers are, uh, you know, this calendar year we saw, 8,000 applications, almost 9,000 applications for 150,000 workers total for the summer season, and then another 2,400 and close to 50,000. So that's almost 200,000 workers that employers are asking for against 66,000 numbers. So where do those other numbers come from? We'll talk about that in a minute. They come from what are called supplemental caps. And every year the government authorizes additional allowances. So there's typically an allowance for, let's see if we can skip ahead here for a second. Um, just while we're talking about this. So right here, we've got supplemental caps, returning workers. So 45,000 numbers for folks who have been in H-2B status within one of the past 3 years. And then that 45,000 is broken up between the first and second half of the fiscal year. And then there's country-specific allocations. Most recently, we had Colombia, Honduras, El Salvador, Costa Rica, Ecuador, Guatemala, and Haiti, which if there are additional 20,000 numbers allocated for the whole year for foreign nationals from those countries. And so those are out, those are in addition to the 66,000. And there's also at the bottom here, you can see extensions and concurrent H-2Bs. So extensions are folks who maybe they worked, maybe you have somebody who worked for the Sunday River Ski Resort as a cook over the winter, and they're in the US and you have a summer H-2B program, you want to hire them, you can apply to extend their H-2B status and transfer their employment over to you, and that can happen outside of the cap. So outside of that 66,000 allocation. So I'm going to back up here. Pardon me for jumping around in the slides. Not intending to give you all whiplash. Um, let's see, back here to the dates. So, um, so I mentioned April 1st and October 1st. Um, Generally for summer employment, which is the highest demand for H-2Bs, generally employers need to use April 1st as their start date, even if their operations may not ramp up significantly until May or June. Um, as long as you have an argument that, hey, if we have the workers available in April, then yes, we can start training them, we can start putting our systems together, and we can open early, these sorts of things. Um, and, for April 1st start dates for next summer, the filing window is January 1st through January 3rd. For winter H-2B needs, you're looking at October 1st start dates as being ideal. And then you need to file your applications between July 3rd and July 5th. So using next summer as an example, thinking about April 1st as a start date, um, and the target of filing January 1, 2, 3. In order to file, then you need a prevailing wage determination, which is a preliminary requirement we'll talk about in one moment. Um, and that's what we're filing for our employers right now. The prevailing wage is essentially a minimum wage for immigration purposes for a job based on the location and the occupation. And so there's an H-2B wage assigned to pretty much any occupation you can think of. And you have to reach out to the government, in the fall here and basically let them know, here's the position we want, here are the duties and requirements for that job. And then the Department of Labor will come back and give an official determination that this is the wage you need to pay. And you need to have that wage determination before you can file in January, in the first few days of January. And so you have to start the process early because when we look at the upper part of this slide and we see the 8,800 applications for 150,000 workers and the 7 processing groups, all of those applications were submitted January 1st, 2nd, and 3rd of this year. And all the applications that are submitted, in order to make it fair, they give you that 3-day window, and all the applications submitted are randomized and assigned into processing groups. And if you're in group A or B, then you're likely to be able to access the cap numbers, the 33,000 that's assigned to your half of the fiscal year. And being able to access those numbers gives you maximum flexibility. You can get new H-2B workers from abroad, and then you would also have the ability to use the returning workers, the country-specific workers, and extensions. So you'd have the full range of options. If you get into group G, the cap will already have been met. And by the time you get your labor certification, and you're going to need to rely on the other, the supplemental caps. Process and procedure. So we talked a little bit about the prevailing wage request that happens in the fall. The January 1st through 3rd filing is the application for temporary labor certification. When you submit that, you're saying, here are the dates I need my workers. Here are the number of workers. Here's my prevailing wage for this job. And then um, once that process kicks off, the government will instruct you to notify your former workers, post a notice at the work site, and then a couple weeks later, you'll file a report back with the Department of Labor to let them know the results of that recruitment. Um, and following their review of that report, the Department of Labor will issue a temporary labor certification for, let's say, 10 workers. And at that point, you'll be looking at moving over from the Department of Labor over to the Immigration Service. And it's USCIS, US Citizenship and Immigration Services, where the H-2B cap comes into play. And when you get that labor certification from the Department of Labor after your recruitment's complete and you filed your report, um, then you're going to be looking to see, well, what what workers can I get? Has the cap on the 33,000 numbers already been met, or can I petition within that cap? Um, can I petition for returning workers? Can I petition for workers from specific countries? What numbers are available? And in some cases, most of those numbers may have already been exhausted, and and you would be looking at extension processes. So looking for workers who, if you're a summer employer, you're looking for folks who were in the US already over the winter working for a winter employer in H-2B status, and you can petition for them to come over to work for you for the summer, and you can do that outside of the cap. So even if you're in group F or G, you should still have access to extension workers. Um, this is more about the procedure. So that we talked about a job order and some of the requirements that are important to think about here. These positions have to be full-time. 35 hours or more is the cutoff. Um, Housing is an important consideration. For H-2A agricultural positions, you must offer housing and pay for it and provide it. With the H-2B program, you are not required to offer housing. Um, and if you do offer housing, you can charge your workers for it. You just have to be clear in your advertising what that framework looks like. Um, and even though you're not required to offer housing, oftentimes practically speaking, it's a requirement, because if you get workers, they they may not have a place to live if you're not able to offer them a place to live, because we know how things are with many communities. The cost of rental housing, particularly in the summers, can be very, very expensive. So housing becomes an issue in some instances, and some employers like to have arrangements with hotels or with summer rentals, things like that, or in some instances, employers have rental properties that they're able to use for worker housing. Um, Again, transportation, travel, and visa costs. You have to indicate in your advertising you're going to be providing those. You have to provide on-the-job training. You have to meet the prevailing wage requirement, and you have to pay overtime if the workers work over 40 hours. Um, as far as wages, typically, you might see a cook who you have a prevailing wage of $21 an hour. Um, you're probably in your advertisement going to want to indicate that you're willing to pay a range of wages, or that you're willing to pay performance-based wage increases or bonuses, because sometimes these workers, the foreign workers, are really in the driver's seat because of the limited cap numbers and the limited number of workers, H-2B workers overall, sometimes, the employers who are able to pay higher wages are the ones who are more attractive to the employees. And if your advertisement says we're going to pay $21 an hour, um, and and the worker that you are talking to wants $24 an hour and you're willing to pay that, if you go ahead and pay that, then you're technically not compliant with the program because you advertised the position at 21, but now you're paying 24, and that's a disconnect that could become a problem if it were discovered. So the way to protect against that is to give a wage range, 21 to 25. And that way, if people are willing to take the 21, you can pay that. If they're requiring more, then you have flexibility to pay them more while still complying with the Department of Labor requirements. Um, a little bit more about the details of the processing. So when you apply to the Department of Labor and say, I need 10 cooks between April 1st and November 15th, they may come back and say, well, we need you to prove that. Give us your documents, show us your payroll. Um, and if they have questions, they may issue a notice of deficiency, sort of challenging whether you have that temporary need. So typically what we do is we know they might ask for that stuff. So we ask our employers for it and we provide it to the Department of Labor in the first instance. Sometimes they might say, we reviewed your payroll and sales data. We don't think you need 10 workers. We need you to justify it. Tell us more. And then we would have an opportunity then to make additional arguments or provide additional data or clarification. Once we successfully convince them of the temporary need, they would issue a notice of acceptance, an NOA. That's when the recruitment begins. The job order with main job link goes live. You post a notice at your work site and you reach out to former workers. About 2 weeks later, you submit your recruitment report, and then you wait for your labor certification to be issued. Um, Employer requirements. So you've got to keep recruiting until 3 weeks before your start date. You're required to pay visa and transportation costs. You have to assist workers with getting social security numbers and cards if they don't already have them. Um, you have to post wage and hour posters and so forth, which you're already required to do. You have to guarantee at least 3/4 of the hours that you're offering. So if you're offering employment from April 1st through November 15th, um, you're guaranteeing that you will, absent an act of God, meaning a natural disaster or something like that, that you will pay workers throughout the entire period at least 3/4 of the hours that you've offered. That's a little bit of a complicated requirement. It requires a little more discussion. Um, and it's also complicated because right now the government doesn't actually have funding to enforce that requirement, yet it's still a requirement that applies. So that's one for a further discussion. Document retention requirements, notification to Department of Labor and the Immigration Service if your workers leave early. Um, you can't offer conditions to foreign workers that are more favorable than those for your US workers. You also can't move your H-2B workers into different jobs or different duties without prior approval. Um, it's Compliance is really the name of the game here. Um, and there's a lot of compliance involved, which is where we come in because we know the rules and we're able to guide our employer clients through the process and make sure that they're aware of what the rules are. Um, and the big thing here is really getting workers who are authorized to work. And a common misconception with the H-2B program is that if a worker is here in Maine with H-2B status to work for, the Four River Hotel for as a cook, that a lot of people think that, and sometimes the workers think this too, that they're here in H-2B status to work for that hotel, but their H-2B status, they think I can go and work anywhere. So I can take a second job. I can work, in a few hours here, a few hours there. And that's actually not true. H-2B employment authorization is employer specific. So if you ever see an employee who you didn't sponsor through the H-2B program, that you didn't file a petition for, and they're coming to you saying, "Hey, I've got H-2B status. Here's my social security card. Here's my visa and my documents. I want to work for you." They're not authorized to work for you unless you petitioned for them through this program. The more I talk to employers about this, the more folks I run into who are not aware of that. Um, and it's an important piece because, as you know, you have to do I-9s for all employees, even U.S. citizens, and um, it's sometimes it's quite an unfortunate revelation for folks. It's also a good reason to consider using the H-2B program because if you use the program and you get H-2B certification from the Department of Labor, then that worker who comes and wants to work for you, then you have a way to petition for them. Because even if they're working for another H-2B employer, you could petition for them to have a second H-2B process, a concurrent H-2B process with you. And that would involve the person having two H-2B employers at the same time, two full-time jobs. Um, and sometimes that works. It's quite a few hours for these workers to put in, but my experience is that there's a lot of folks who want those hours. They want to work. They're here to work, and that's one of the reasons that U.S. employers like the program is because they get workers who are really dedicated and hardworking. A little bit more about the numbers. We saw this slide earlier. Um, Regular cap at the top, you've got your 66,000 divided between the two halves of the fiscal year. You've got your supplemental cap of a total of 65,000 additional workers. 45,000 of those are returning workers who've been in H-2B status in the past 3 years. Another 20,000 are from specific countries. And then you've also got your extensions. We talked about the Sunday River cooks already in H-2B status coming to work for a summer employer. And then we just talked a minute ago about concurrent H-2Bs, folks who are holding two H-2B employment statuses at the same time. These are the options. So when you go through the Department of Labor process, you get your certification from them where the Department of Labor is saying, okay, we agree you need 10 workers for these months. Um, and you take that labor cert, you're going to be looking at these options. What's available? Um, let's see. Group assignments. So I mentioned this a little bit earlier, and I'm trying to move quickly here so I can allow time for questions. So I mentioned groups A and B. You're likely to have the full range of options. These are the processing groups. When you file in January, um, when you have 8,800 employers filing within a 3-day period, filing their applications. All of those applications are randomized, and groups A and B have the best options. Groups C, D, and E have a good number of options, but probably can't access the regular cap. E, F, and G, fewer options. They may be looking at the country specific numbers or relying on extensions or concurrent employment. Um, and I have a note of reassurance here. Most employers eventually get workers. It's just a matter of, how the randomization process plays out and kind of where you end up on the other end. That's where we come in again, is to help folks um, really try to file at the earliest possible time, try to get their recruitment reports back to the Department of Labor on the earliest possible date, and just stay ahead of the process every step of the way to maximize the chances of an advantageous positioning. Timelines. So basically, you want to start planning and file prevailing wage requests early, a few months before you're going to have to file your temporary labor cert. So for winter processes where you're filing in July, you want to be starting in February or March. And for summer processes, you want to be starting your planning August, September. And then right about now is when you want to be getting your prevailing wage filed, so that you have that prevailing wage determination for your January 1st filing with the Department of Labor. And once you file that, it's kind of away we go. Usually March through May is when folks are filing petitions with immigration, and they start to see your workers coming in. Compliance and record keeping again. Got to follow your job order. Um, got to keep your documents in case immigration wants to review them. A lot of documentation is not submitted to the Department of Labor. They're trusting that you did what you said you did. Um, that's where we come in, is to make sure you know what you can and can't say and what you can and can't do. Um, and this last bit here we discussed, as far as you can't hire H-2B workers who are sponsored by other employers. Um, Challenges with the process. The randomization is the biggest challenge. It is a lack of predictability to some extent, but overall, the H-2B program tends to bring more predictability to the summer season or the winter season. Um, you know, Challenges can come from delays with processing when you're relying on government agencies. You're relying on things out of your control. So that can get frustrating. But again, staying ahead of the process is the name of the game. Um, Transferring workers from winter to summer or summer to winter can get a little complicated as far as timing and when uh, when the employees are ending their previous employment. Um, there is, we talked about these extension workers who can be, for example, working for Sunday River, then come and work for us, the Four River Hotel in the summer, and they can go back and forth without ever leaving the country. They can do that for a total of 3 years. Um, and eventually they'll hit a max, and they have to spend at least 60 days outside the US in order to get a new 3 years. That can get a little tricky as far as timing. Um, and yeah, that's your crash course, folks, in the H-2B process. Um, very quick. We could probably spend a whole day going over the different elements of the program and all the ins and outs, but um, that's an introduction and overview, I'd say.
Marcus, thank you for providing that. That was very helpful and timely as we're going into thinking about the next summer season already. We received a few questions ahead of time and got some earlier. Could you briefly explain the difference between J1 and H-2B visa for these folks?
Absolutely. So um, the J1 status is for exchange visitors, and that actually encompasses a bunch of different categories. It can include au pairs, like nannies. It can include research scholars and things like that. But where seasonal employment comes in, it's usually the work and travel program, which allows foreign nationals outside the U.S. who are generally they're in college. And during their summers, they can come to the US to work for a few months, and then they get a 30-day grace period during which they can travel. That's why they call it the work and travel. And the difference there is really that you're looking at 3 months of employment usually, because these folks, they finish up their schooling in the spring or early summer, and they can come over, maybe starting in May, but typically June, July, August, maybe into the beginning of September, and that's it. Um, Whereas with the H2B program, you can have folks for a lot longer. Generally, J1s aren't going to be available for winter employment. And for summer employment, H2Bs can start a lot earlier and work a lot later. And, in Maine, a lot of employers, it's not just summer. The season kind of can stretch into October, even November, when you combine, you know, the heart of the summer, warm winter, the warmer months. Then you've got kind of a shoulder season, and then you're into where we are now with foliage season, which is still can be, there can still be a lot of tourists. That's the biggest difference. There are a number of differences in how the program's uh, administered, but you know, um, the biggest difference is the amount of time you can get the workers.
And you're right about that difference in when the season is happening, especially the last few years, we're seeing a more rainy spring into early summer and kind of a warmer September, October, November as the seasons are shifting. We also received a question about have there been any changes allowing young people to be permitted to work on the H-2B visa in 2026?
There really have not. 18 years old is generally the minimum age for foreign workers, for foreign H-2B workers. Um, and that's, even though you might be able to employ folks who are US citizens or permanent residents, you might be able to employ them depending on state law at a younger age. 18 is generally going to be the minimum cutoff, and that hasn't shifted.
If anybody that's attending has questions, feel free to unmute yourself and ask that question. We want to give you that opportunity.
Well, hello, Nate, for hosting this event today.
Hi, Ed. Thanks for
Hi.
being here.
Um, are there organizations or companies that do a lot of this for you and you pay them to file all the government paperwork, and maybe you pay them per employee, and um,
Yes. Yeah. So, I mean, we as a law office, we don't provide recruitment services, so we don't generally work with identifying workers either outside the US or in the US, but we do file all the paperwork for our clients, as every step of the way. So there's materials that you as the employer would need to review and sign, and we would walk you through that. But we're taking care of all the deadlines, all the submissions to the government, all the correspondence. Um, there would be, requirements, for example, for you to post notices at your business, and reach out to former workers and things like that that only you can really do. Um, but again, we're guiding you, and we're very accessible, to work alongside you through those steps. And then as far as finding the workers and petitioning for them, uh, even when they're outside the US, we do work with several recruiters who, they do charge additional fees per worker to, assist with visa applications abroad, or, kind of finder's fees for identifying workers sometimes in the U.S. Um, and together between our office and recruiters, employers are able to kind of um, reduce their burden substantially in terms of working through the steps of the program.
Marcus, what would you say would be the average cost um, to
Well, the
get,
cost,
excluding
the cost,
wages?
yeah. So the cost of legal fees and filing fees with the government, um, it can vary somewhat depending on specific circumstances. Generally, and I hesitate to kind of give, quotes without really getting into a specific employer situation. But generally, for there's really two phases of the process. You've got the Department of Labor phase and the immigration phase. And the Department of Labor phase, you're generally looking at legal fees of around $5,000 plus expenses. Um, and that could be less or more depending on circumstances. And then for the immigration phase, you're probably looking at, you know, it could be another 4,000 roughly, you know. Um, but the nice thing is that at least on our side for legal fees and government processing, and you know and those numbers include the filing fees with the government as well, um, for the most part. But we're their per worker fees don't really come into play with legal fees. Um, Sometimes when we're filing a petition with immigration, um, and we're identifying specific workers, and we have to provide the history of their status, all of their passport and biographic documentation, proof of their maintenance of status through pay stubs and things like that. That's a lot of documentation to collate. And we do charge different fees if somebody's um, filing for 15 or 20 specific workers versus, 4 or 5, because the amount of time we're putting in is different. But generally, when you're filing a Department of Labor process, the costs are often the same whether you're seeking five, 5 or 10 workers to come on for the busy season or 30 to 40, because it's all done based on the occupation. So you're saying cooks, we need cooks, we need 10 cooks. And it's not kind of each individual cook brings up the cost. It's really focused more on particular occupation.
Payroll taxes?
Okay, hold on one second, Ed.
Sorry.
This is Kathleen. I'm with Hospitality Maine. Are you doing a story? Because I just want to make sure that Marcus knows if you're asking questions for an article.
No,
No. All right,
no,
but you're a journalist, or am
no,
I thinking of another Ed Morgan?
no. Oh, you must be thinking of somebody else.
Okay. So all right. Sorry about that. Continue.
No worries. Employee taxes. Uh, I assume that if an employer went this route with a law firm, you would pay the employee directly.
Yes. Yep.
And
You're going to pay these workers the same way you would pay your U.S. workers, with all the same requirements as far as FICA and yeah, payroll tax and so forth. It's really they're just going to be on your payroll basically. Yep.
Marcus, a question that came in was recognizing, do larger businesses with more employees get preference over smaller businesses, or is it just based on demonstrated need?
Great question. The answer is the randomization process, the group assignment process we talked about, is designed to level the playing field so that if you have a small employer who needs 4 additional housekeepers, and they put in their application for temporary labor certification between January 1st and 3rd, that one application is going to be treated the same as the one application from, the Hyatt or whatever that needs, 50 additional housekeepers, because both of those are single applications seeking housekeepers. And so they're going to be assigned to their groups randomly. And yeah, there's no advantage for the big employers in that respect. The larger employers, when they get into Group A, and they get 50 numbers available in Group A, that they're taking up more of the numbers and using them faster, and so that can create a disadvantage for others. But as far as where they land in the randomization process, the process is designed to be random and be an even playing field.
It's great that's taken into account. It's with Maine as a big small business state.
Absolutely.
Well, if there are no other questions, Marcus, thank you again so much for walking us through that. For everyone joining today, we'll be sharing a recording and slide deck after the session concludes. If you have any additional questions, you can see Marcus's contact information here. That's the best way to get a hold of you, I assume, Marcus, for any follow-up.
Yes, happy to answer more questions, and yeah, email or phone would be a good way to set up a time to connect. Thanks everybody for listening and tuning in. Appreciate the opportunity to share some information about this program, and thank you, Nate and Kathleen, for having me.
Thank you.
Thank you very much, everybody. Have a great day.
Thank you.
Take care.
Thank you.